building. Now, at this time, before we begin the CLE, I would like to acknowledge and express our appreciation to the committee that planned this program. The roundtable discussion was planned by Lori Vitale, along with her subcommittee, which includes Judge Shelley DeVouge, Kim Wallace, Deborah Shandles, and there are a variety of table leaders at each of the tables, I believe. I also at this time wanted to thank, is David Long here? Where? Right in front of you, the middle. Can you come up here, David? And while he's coming up, I'll remind you that our CLE committee is chaired by Shannon Joseph, and the program planners are Rick McElroy and Julia Wicker. And also wanted to thank the Bar Association staff for putting this together today. Now, David, the reason we wanted you to come up here is you were not able to be with us in San Francisco at the ABA meeting in August. And we decided that it would be very appropriate, why don't you get over here, for us to actually give you the Smith-Gambrell Award. Now, you have to give this back because Alice gets to keep it, but you can hold it for a while since your committee has spent so many years doing so many things in the area of professionalism, and it's the reason why we got this award. And thank you so much.
This is truly a committee award. The committee, I have been working with the Professionalism Committee for, I guess, close to 10 years, and it is a pleasure every meeting because everybody participates, and we all work together, and we accomplish together. And I want to make sure that everyone in that committee gets a round of applause as well.
Absolutely. Thank you so much. Thank you. All right, and now I'd like to call on Lori Vitale, and we'll get our program underway.
Thank you. I'm Lori Vitale, and I'm so excited to see all of these people here, all of you here for this roundtable discussion. This is our third year for doing this program, and today's problem will focus on Rule 3.4 of the Rules of Professional Conduct. Was recently amended to include potential ethical implications if there is a violation of the discovery rules. This is in both the civil and criminal context. Now, we may have more tables than we have table leaders, so if you don't have someone at your table with a blue tag on that says table leader, please, someone volunteer at the table to be the table leader. There's a white packet in the middle of the table, and it has a cheat sheet in it for whoever will lead the table.
Poor choice of words.
I guess that was a poor choice of words for an ethics program.
A guide.
It is a guide. You will have 30 minutes to review the problem and to discuss the questions that follow the problem. There'll be two table summaries given at the end of the program, one by Mark LaMantia, one by Sally Scherer. After that, we will have a summary given by Doug Brocker, who, for those of you who don't already know, practices in the area of professional license defense. I want to thank you all for being here and participating in this. And also, just as a reminder, our guests from the Ukraine may pull a table up to you, or pull a chair up to your table to join in on the discussion. So, thank you. And we are going to start with the table summaries now. So, Sally, are you ready? Can you? Okay. Our first table summary is going to be given by Sally Scherer.
Well, if any of you can see who is at the table with me, you will know we never finished the problem. However, we're pretty hard on folks. So Peter Partner has a real problem, and he is, in our opinion, made lots of mistakes. The obvious one is not telling the bar, which is an ethical violation, not telling his partners, telling Babyface to go lie to the court, telling Debbie to object to discovery. Does anybody have any problem with those as being ethical violations? Some of the things we didn't think were, but I'm not going to go into all of those. But we had some questions in terms of the email. If he's simply deleting it, is that an ethical violation? How does he know at that point in time, et cetera? What was his duty to clients, to partners, versus it being an ethical obligation? I'm just going to go through the different people involved that we managed to get through. Carlton Lewis, we don't believe that there was an ethical violation because Lewis, we don't think, had an obligation to disclose the email when the DA said to the court that all the discovery, I think it was, had been produced. Too much of this may depend on exactly what's said by the DA and what was requested, et cetera, but in our opinions, from what we know, we didn't think there was an ethical violation. And on Babyface, we didn't think there was. This is an interesting question, but as I sat there thinking about if Joe Cheshire is my boss and he tells me to go tell the court something, I'm not asking him, did you investigate it? And I don't think many new lawyers are going to be doing that. However, it was pointed out that maybe as a new lawyer, you should be very cognizant of the demeanor of the senior lawyer telling you to do something. Do they seem like they're not telling the truth? But I can't get to an ethical violation on that. We didn't finish everything, as I said, but it was very clear from the very beginning of this problem that everybody at the table felt that poor Peter Partner was in trouble because ultimately he was accused of sex when he didn't even have any.
Thank you, Sally. I did confirm the CLE credit, partial credit is 0.75. It is not an hour. Our next table summary is going to be given by Mark LaMantia.
We also didn't have time to finish the problem. There were an awful lot of questions, although I will say that our factual summary didn't say that Peter Partner didn't have any sex. So we just took it on faith that that was an inappropriate statement since there was no indication in the factual summary that there was evidence to support it. Although the bad judgment might be indicative that that could be the case. We felt similar on the key questions. I mean, obviously, under Rule 1.15.2 sub 0, the obligation to report the funds disappearance is absolute. I don't think there's any question that it didn't have to be reported to the bar. What happens beyond that, we had an interesting discussion about, and I had the benefit at my table of having some long-experienced members of the Wake County Bar to shed some light on what they thought on some of these questions, and so it was very interesting. But the questions that sort of presented the biggest problem for us in the first one had to do with duties to clients and law partners. Certainly everybody felt that the duties to the law partners was absolute. As far as the duties to the clients, there was simply a lot of discussion about once this problem is uncovered, what you do to take care of it. I think where we came to a general consensus is that there was an obligation to report it to your partners and to determine with your partners what you're going to do to address this problem, presumably since you have to report it to the bar in conjunction with the bar. And what we talked about was whether or not you would simply have to all get together and ante up and replace the funds so that clients' funds were not in any danger and that whatever repayment arrangements were made, if you wanted to make them, were made as a group with Debbie Defendant, who I would assume wouldn't work for you anymore. The reporting to the Assistant District Attorney, we pretty much came out to a no on. but it was kind of dependent on the rest of the questions in terms of whether you have an obligation to prosecute or report prosecution, if you can resolve things by yourself. But certainly it wasn't something that Peter Partner should have ever tried to do on his own. As far as Carlton Lewis goes in number 2, we felt that he was probably obligated to disclose the email in reciprocal discovery, although we had some question about that just based on the technical language of the rule that talks about whether you intend to offer it into evidence or not. And we didn't have time to discuss whether we really felt it was something he would use for his benefit or use in evidence. And so that was the only issue we had, but when it came time to make a determination, we felt he probably should have disclosed it. And consistent with that, he probably shouldn't have remained silent. We never did get to really determine whether it rose to the level of an ethics violation because we felt that was beyond our capability. Peter Partner violate by objecting to the discovery and directing Babyface to represent there were no relevant emails. We came out yes, just like Sally's group. On the issue of Babyface, we reached no determinations because that's about where we had to really speed up and move through things a little bit. And I think it's a practical problem, like Sally indicated, and we've all seen the movie The Firm, which sort of deals with exactly that. If you think something bad's going on at your firm, what is your obligation as a junior lawyer or a lawyer to do it? I do think you have to independently review material. I don't think you can simply rely on the word of people senior to you, even though sometimes that may be bad judgment. And we did talk about the rule where it has some, there is a specific rule at 5.2 dealing with responsibilities of a subordinate lawyer. We didn't think Larry Lawyer's case was even reasonable at our table. So we concluded that he was overly broad, irrelevant, and unduly burdensome, and that it was improper, and that his closing remarks at trial were improper too for pretty much the same reason Sally had.
Okay, thank you, Mark. Our final summary is going to be given by Doug Brocker.
I just want to quickly hit a couple of the sort of the three central ethics issues that this problem raises. And since I didn't have anything to do with drafting it, I can say that Lori and her subgroup did a great job of sort of giving some examples of things that are either nuances of the rules or changes to the rules. The first one is the duty to report misconduct. It's easy when you're given a package of information, you can read it to see pretty clearly that you have a duty to report any misappropriation of funds. Duty to misappropriate funds, yes. And it doesn't matter whether it's a lawyer or not. But one of the interesting things is if you were trying to figure out what your obligations were and you just look to the rules, there's a specific rule, 8.3, that says duty to report misconduct. And if that's all you read, you would probably come to the conclusion that you didn't have any duty to report this unless you went on and read the misappropriation rules. So it's a good lesson that you got to be careful to make sure you're really familiar, particularly with something this sensitive. Because the general standard for reporting is just, does it raise a substantial question about the lawyer's honesty? Doesn't have anything to do with non-lawyers, your general reporting obligations. The other second issue was really about the discovery rules, and the real significant change that went into effect in November has to do with incorporating your obligations under discovery in civil and criminal contexts into the rules of professional conduct. And it arguably makes violations of those also violations of the rules of professional conduct, which it didn't before. The real question is, does that mean that every discovery violation constitutes an ethics violation? And there isn't any clear answer to that, but certainly, in my opinion, I don't believe the State Bar wants to become the discovery police. And I think those rules are going to be applied in a sense that generally where you're talking about intentional failure to provide information or failure to let people know that you're withholding information intentionally, that's going to rise to the level of an ethics violation. If it's unintentional, an example from the problem, Larry Lawyer, yeah, maybe they're overly broad. I think they are overly broad, but I doubt that that rises to an ethics violation, even if it is. And I think as long as you do reasonable diligence and you disclose what you're not providing, it's not going to rise to the level of an ethics violation. And the last thing, quickly, about representations to courts, it highlights one other distinction in the rule, which is there is a real difference in the ethics rules about representations you make to a court based on something that somebody else has told you and based on what you yourself know or represent as being your own knowledge. Babyface is told by effectively his client or his senior partner that doesn't exist. If he makes that representation and it's false, he's got a reasonable reliance and he's not going to be held in violation of the ethics rules. But if he gets up and represents to the court on a different set of facts that we've checked and that information does not exist in the firms and it's based on his own recklessness and not checking, then that probably does rise to the level because he's making a representation based on his own knowledge, not based on that of a client or some third person. And I think Lori and her committee did a great job of highlighting those. Thank you.
Hey, thank you all for participating in the program, and thank you, Doug, for the summary. And that concludes the program. My name is Julia Wicker. I'm an attorney at Helms, Mullis, and Wicker in Raleigh, and I am a committee member of the Wake County Bar Association CLE committee. At this time, we want to thank Doug Brocker for being a speaker today. Doug is special counsel to the North Carolina State Bar, and he prosecuted the disciplinary case against Michael Nifong. He is a principal in the Brocker Law Firm, and we sincerely appreciate his time today. He is going to discuss and present on lessons learned from the Duke Lacrosse case and State Bar versus Nifong. At this time, I'd like to introduce Doug Brocker. Thank you.
Can you hear me? Okay. Can you hear me in the back now? All right. Wanted to start off, normally I concentrate my practice in representing lawyers before the State Bar and other professionals before their licensing boards. And as Julia said, I'm here to actually talk to you about sort of the reverse of that situation. I am not, but I was, for the Mike Nifong case, special counsel to help prosecute that matter, along with Catherine Jean, the counsel to the State Bar, and Carmen Hoyme, one of the deputy counsels. And that's what I really want to speak about. That case involved a number of interesting ethical issues. And I'm going to talk primarily just about one because Brad Bannon and Joe Cheshire are going to speak afterwards, and they're going to deal with at least one or more of the other ethical issues that came up. As the ethics rules note, a prosecutor like Mr. Nifong has a responsibility as a minister of justice and not just as an advocate. His duty is to seek justice and not merely to convict. And in my opinion, no other legal ethic issue really resonates with the public as much as when a prosecutor misuses that trust and responsibility. And I believe that's why that case continued to garner such media attention, almost unprecedented media attention, right through the disciplinary trial and the proceedings. During the next half an hour, I'm going to highlight really the first issue that came up in that trial, which to some degree has been overshadowed by some of the other matters having to do with DNA and discovery and misrepresentations to the court, and that is the prejudicial effect of extrajudicial statements. The Duke Lacrosse case is a good example of how badly the justice system can go awry when lawyers, particularly prosecutors, but all lawyers, don't honor their ethical obligations. I think it's a particularly demonstrative example. And before I jump into that, though, what I want to do is to show a short clip from the disciplinary trial, which hopefully you'll be able to hear. And the reason I do that is sometimes the ethics rules come across as very esoteric, sort of ivory tower kind of issues that don't really have an impact on real people. And I think this clip is a good illustration of the actual impact, personal impact on folks. And the clip I'm going to show is from Reed Seligman, who was one of the players who was indicted and faced up to 30 years in prison for these alleged crimes. Just by way of background, Reed was a 20-year-old college student athlete. He was recruited by Ivy League, all the Ivy League schools, got scholarship from numerous other Division I schools, did very well both in high school and college. He received many different awards leading up to this point, including ones recognizing him for outstanding moral character, and just generally was one of the nicest young men you'd ever want to meet. And the context for this clip is his testimony describing his attorney at the time, Julian Mack, receiving a phone call from Mike Nifong's office telling him that he was about to be indicted for rape and kidnapping on Easter Monday, which also happened to be his mother's birthday.
On the phone. And my first reaction was, oh my God, it's one of those two. And he picks up the phone and he briefly glances up at me, and you could see, his face, the coloring in his face was changing. And my dad and I just sort of stared at each other. And you get that feeling in your stomach, that pit. And you don't even know what to do. You don't want to believe it, but you want to know. And he asked us to stand in the other room. There was a conference room, and we're standing in there, and we're just circling, and we're like, the room felt like it was spinning. And Julian comes in and says, "She picked you." And my dad just fell to the floor, and I just sat on the ground, and I said, my life is over. And then we finally got up, and me and my dad were hugging each other, and Julian didn't even know what to say. And the first thing I thought about was, how am I going to tell my mom?
That, I think, better than anything else, encapsulates the human toll that this case and these ethics violations had on individual people, in addition to the harm to other prosecutors, to the state of North Carolina, to the justice system, and various other people. As a result of his indictments, which he mentioned, he uses the expression, "she picked me." And what he's referring to is that twice before, the alleged victim had been shown photo IDs and hadn't been told anything about the people in those identifications. On a third occasion, directed by Mr. Nifong, she was shown 46 pictures and was told point blank, these are the people that we believe were at the party. And this is a very important case, et cetera, et cetera. Essentially, she was given a multiple choice test with no wrong answers. And Reed was one of the people that she picked out, and based exclusively on that in Reed's case, he was indicted for rape and kidnapping. And as a result of that, his mother had a nervous breakdown. His father lost his successful business because he couldn't work. He was kicked off the Duke campus. And, of course, he was plastered all over the local, national, and even international news media. And the other two young men had similar stories. I use Reed because he was the one that actually testified at the hearing. That really started, that human toll and consequences really started in this case with where the case went wrong initially, which was the pretrial statements. And it's important, and that's primarily what I want to focus on today in the short time that I have. It's important to keep in mind that the prohibition against pretrial statements is based in large part on the Fifth and Sixth Amendments to the U.S. Constitution. What Rule 3.6 prohibits are extrajudicial statements that the lawyer knows or reasonably should know will have a substantial likelihood of materially prejudicing an adjudicated proceeding. Basically what that means is you can't make statements outside of court that you know or think are likely to impact the trial in some way. That's the gist of that. And that prohibition is really based on the Sixth Amendment right to a fair trial by an impartial jury. Exactly 100 years ago, Justice Oliver Wendell Holmes said in addressing the right to a fair trial, "The theory of our system is that the conclusions to be reached in a case will be induced only by evidence and argument in open court, not by any outside influence, whether of private talk or public print." Now, of course, Justice Holmes's comments were long before the widespread use of the broadcast media or the internet, which pose significant additional threats to those constitutional protections if the rules and the prohibitions are not respected. The standard in Rule 3.6 is fairly vague, and so the comment, particularly comment 5 to that rule, sets forth some very specific examples of the types of things that are presumed to have an adverse influence on eventual trial. The first one of those is that a prosecutor should not comment upon a suspect's refusal or failure to make a statement, and that is based on the Fifth Amendment right to remain silent and against self-incrimination. I'm going to go over a few of those specific, but I want to talk about some of the specific comments that Mr. Nifong made that were in obvious violation of that comment and prohibition. In local news, immediately after he began his involvement in the case, he says, he was quoted as saying, "I guess that some of this stone wall of silence that we may have seen may tend to crumble once the charges come out." He's talking about a stone wall of silence. Another article where he's quoted, he says that the team members are standing together and refusing to talk with investigators, and he warned about bringing aiding and abetting charges. Again, both comments where he's commenting directly in obvious violation of that comment about a suspect's right to silence. But like most of his comments in this case, it wasn't really just limited to the fact that they were obvious violations of the rules, because when you compared it to what the evidence was, it was more troubling. He described the players as having a wall of silence. And what you see coming up on the screen now are 3 different sets of detailed written statements that were provided by 3 of the team members in questioning by police over the course of numerous hours when they were first contacted. They described exactly what they contended happened from the minute that the dancers got to the party until they ended. And it's a little hard to see on the screen, but you can see in those they gave detailed lists of everybody that they could think of that was involved in these parties. And that was information that Mr. Nifong had when he began making any of these statements. And when you contrast that to what he was actually saying, describing this as being a stone wall of silence and refusing to talk with investigators, he made another comment about why won't they tell us in their own words what happened if they haven't done anything wrong. And it's troubling that not only was it a violation of the rules, but a lot of the statements he made, including these, were just contrary to the evidence that he had. Another one of the things that's protected specifically by the rules of professional conduct that you can't comment on is under the Sixth Amendment right to counsel. You can't make any statements about somebody's assertion of their right to counsel. A couple of Mr. Nifong's comments about that particularly, the lacrosse team clearly has not been fully cooperative. Again, he's referring to the alleged silence. And he says, I think their silence, again, that's one, we've already talked about, that's one violation, is the result of advice with counsel. So now he's captured 2 different prohibitions in the same comment. And then he goes on to say, I understand that it's likely that what they're doing is a result of advice of counsel, but although that may be good legal advice, I don't think it's good moral advice. So again, he's commenting on the right to silence, their assertion of their comment, and apparently Brad and Joe were giving bad moral advice, even though it might have been good legal advice, according to Mr. Nifong. And then my personal favorite, one would wonder why one needs an attorney if one was not charged and had not done anything wrong. Well, of course, that's precisely what you can't say. You cannot imply in any way that somebody's being silent because they're in fact guilty of a crime. Of course, another good reason that you would hire an attorney is if you were falsely accused of a crime. And ironically, of course, that's exactly what happened in this case, and it makes those statements, particularly the one implying that they're guilty because they won't talk, that much more aggravated. The next comment to the rules that I want to discuss about pretrial statements, you can't speak about the expected testimony of a party or a witness, and you also can't make extrajudicial statements about the performance or results of any examination or test or physical evidence to be presented. And I want to show you another clip, not from the disciplinary trial, but this is actually from an appearance Mr. Nifong made on the Dan Abrams show. And if you give me just 1 second.
This is the first TV interview.
Get it to the right place, which his comments relating to that particular prohibition in the rules. This is in response to Dan Abrams' question. He starts talking about the victim in this case and whether or not testing was done on the players.
That's a possibility, and certainly we did investigate that particular possibility. But let me point out that the evidence that she would present with respect to that particular situation is that she was grabbed from behind, so that in essence somebody had an arm around her like this, which she then had to struggle with in order to be able to breathe. And it was in the course of that struggle that the fingernails, the artificial fingernails broke off. Now, as you can see from my arm, if I were wearing a shirt, a long-sleeve shirt, or a jacket of some sort, even if there were enough force used to press down to break my skin through the clothing, there might not be any way that anything from my arm could get onto those fingernails. So again, whether or not there'd be any evidence would depend on exactly the situation. Were the fingernails actually in contact with the skin, or are they in contact with clothing?
Understood.
Again, Mr. Nifong on national television talking about the expected testimony of his prosecuting witness and talking about the physical evidence that may or may not exist in the case. And there Mr. Nifong is showing his chokehold demonstration outside the Durham County Courthouse where this case would have been tried if he had ever been able to get it there. He apparently wasn't content with that in the MSNBC Dan Abrams interview, because he went on to talk about specifically the DNA testing. And the evidence came out in the disciplinary trial that right before he made these statements about the DNA testing, he had just found out from the SBI lab that there was not going to be any DNA evidence from any of the players on any of the rape kit items. And so he goes on, and he was asked about that. He makes the comment to Dan Abrams, if a condom were used, then we might expect that there would not be any DNA evidence recovered from, say, a vaginal swab. Well, again, problem number one in that statement is he's not supposed to be talking about what evidence and what testing has been done. But to compound the problem, he's essentially trying to explain away why there isn't going to be any DNA evidence on any of the rape kit items by suggesting that a condom might have been used. Mr. Nifong at that point had read the report from the emergency room where the alleged victim had said over and over and over again that no condom was ever used in this. So in addition to being a clear violation of the rule, he's suggesting the absence of DNA information by a hypothetical which he knows is not true because the victim has said. He tried to explain that later by saying, well, you know, victims don't always know if a condom's used, essentially saying apparently he knows better than she does whether or not a condom was used in this attack. The next comment in the rules that talks about pretrial statements he is not allowed, nobody, this rule applies to any criminal or civil lawyer, prosecutor or not. You cannot make extrajudicial statements about any opinion as to the guilt or innocence of a defendant or suspect in a criminal case that could result in incarceration. And there's additional comment, which I don't have up here, that says a prosecutor cannot even comment that somebody has been charged with a crime unless he also explicitly states that it's merely an accusation and the defendant is presumed innocent until proven guilty. Obviously, these prohibitions are based on the critical presumption of innocence in the Constitution. Just want to show you a couple of Mr. Nifong's comments in this regard because there were many. He said to the local news media, "The guilty will stand trial. There is no doubt a sexual assault took place." And he goes further and says, "There's no doubt in my mind that she was raped and assaulted at this location," meaning at the lacrosse party. And then goes on and says, "I'm confident a sexual assault took place in that house." After these statements, at least the first three, were made fairly early on. After Mr. Nifong had gotten essentially all the information that he felt he needed to go forward and was just a few days away from indicting two of the players, including Reed Seligman, he went to a candidates forum. He was in the middle, as many of you know, probably all of you know, he was in the middle of an election for the district attorney in Durham. And he went to a candidates forum and he made some comments, particularly that related to this issue that I want to just show a brief segment of.
The reason that I took this case is because this case says something about Durham that I'm not going to let you...
I'm going to play that again when we get the volume up a little bit.
The reason that I took this case is because this case says something about Durham that I'm not going to let you see it. I am not going to allow Durham's view in the mind of the world to be a bunch of lacrosse players from Duke raping a black girl in Durham. And you know, here's the other thing. There are 46 members of that lacrosse team at Duke who gave DNA samples to be tested. And there weren't 46 of them that did this crime. It is just every bit as important to find out who is not responsible and to let them leave Durham without that cloud hanging over their head about, my goodness, look at that, he used to be a member of the Duke lacrosse team, he must be a rapist.
I know that was a little hard to hear, but essentially Mr. Nifong is out there telling the entire world, as it was rebroadcast, that the lacrosse team raped a black girl in Durham. This is before anybody was ever even indicted. No qualifications. In fact, one of the things that was very striking is when you looked at all of his pretrial statements, there was never once the word alleged never appeared in Mr. Nifong's statements. Never. Not one that was quoted that we could find. And he's essentially announcing the guilt of these people before anybody's indicted. The second half of that, ironically, is where he's up talking about it's just as important to have people be cleared of this thing, which it now is very ironic because this candidates forum speech happened the same day or the day after his lead investigator came to him and said, "We don't have any evidence, particularly on Reed Seligman. What in the world are we going forth on an indictment for?" And Mr. Nifong said, effectively, "I'm going forward." So, you know, the comments about the opinions also, like the other statements, are troubling not just because they're obvious violations, but because they really just contradicted all the evidence. The evidence that Mr. Nifong had, at least by the time he was making that comment, was the accuser had made numerous inconsistent stories. She had described the attack against her anywhere from 20 to 3 people that were involved. That's probably the most significant or obvious example, but their inconsistencies were almost too many to count. He knew about her extensive psychological history, including bipolar disorder. He knew the players had adamantly claimed that she was lying, and maybe most significant in terms of the statements he was making, he knew that when the other dancer, the only other person there besides the lacrosse team, had been contacted initially by the police, she said the whole allegation was a crock and she was never away from this woman during the party. She'd been unable to identify her attackers, and then, again, relevant to his intent in making these kinds of opinion statements, the lead investigator testified that in their very first interview, as they were going through much of this evidence, Mr. Nifong commented back to the lead investigator, "You know we're effed," referring to this case and all the problems to it. And that comment in particular was made before he made any of his other statements, where he was out there publicly. Privately, this is what he had. Publicly, what he was saying was, again, there's no doubt a sexual assault occurred, and there's no doubt in my mind. And again, the juxtaposition between not just the obvious violations, but what the evidence showed and the statements he was making was very troubling. The last thing, specific comment I want to talk about with respect to prohibitions, you can't make statements outside of court that relate to the character, credibility, or reputation of a party, a suspect, or a witness. That's, again, for anybody, not just for prosecutors. Now, there is a special prohibition for prosecutors that says you can't make any statements, extrajudicial statements, that have a substantial likelihood of heightening public condemnation of the accused. And I just want to cover a few of the many things that Mr. Nifong said, that just the word and phraseologies that he was using in these statements I think is important. He described it as absolutely unconscionable, racial epithets, described it as a gang rape, one of the worst things to happen, contempt for the victim that he claimed was shown, described it as totally abhorrent, described all the lacrosse team as a bunch of hooligans. He liked reprehensible. He said particularly reprehensible, extremely reprehensible, another layer of reprehensibleness, racial slurs and general racial hostility, most offensive and invasive, appalled, and I think that's probably Joe's favorite, because in that same interview he said that he thought that if Joe wasn't representing one of the players, he would probably admit that he was appalled by this conduct as well. Described as being horrified by the allegations, the racial motivations, and that she was struggling just to breathe. Those comments aren't just, they don't just increase condemnation. The words are very carefully chosen with the intent of increasing condemnation on the players. And this picture and the explanation of it, I think, is a great illustration of how badly that can go. This is a picture of Reed Seligman again at his first appearance. And if you don't know him, probably it's a little hard to see on the screen up here, but if you know Reed, that's pretty much a look of utter terror on his face. And the reason is because after all these comments were made, before his first appearance, he got led into the courthouse in the first place through a gauntlet of media and protesters, including members of the new Black Panthers Party, who were yelling out threats at him, including things like, "You'll get yours, rapist." Then he comes into the courtroom, and he sat down in the courthouse right next to Mr. Nifong, and it's not any of these people in this picture, but somebody sitting essentially where the people are behind him is right behind him. And he yells out loud enough for the people in the courtroom to hear, "You're a dead man walking," right in the courthouse before the judge comes in. And I would say to you, it's hard to imagine a worse example of increasing public condemnation on an accused than having a death threat shouted at you in open court in North Carolina. Now, I'm going to finish up, because I just have a few minutes left, by talking about what I think is one of the most interesting aspects to this, which is why in the world would a prosecutor with almost 30 years of experience make such comments which are in such obvious violation of the rules. Well, one of the reasons he admitted, oddly enough, was he said, essentially, I was very frustrated that the players wouldn't talk to my investigators, and I wanted to put pressure on them. And the comments that I made were designed to put pressure on them to come forward. In effect, what he's saying is, I was making comments to try to heighten public condemnation on these players to get them to come forward. And if that's not bad enough, essentially what he was doing, because he knew that it was the result of counsel, he was trying to violate the rules to get them to disregard their constitutional rights and their lawyer's advice. So that's one of the things that he actually admitted. One of the other primary motives certainly was not admitted, but the effect of his statements make it fairly clear. Do a brief timeline here. March 27th is when Mr. Nifong effectively takes over this case. It's when he's briefed by his investigators where he makes that comment about the bad evidence that's existing. And it's also exactly when he started making all his pretrial comments, March 27th. On that same day, his primary opponent in the election, Freda Black, conducted a political poll. And the question that was asked was a basic question. If the election were held today, who would you vote for? And the results of that, you had Keith Bishop, who was also in the race, but primarily at this point it was between Freda Black and Mike Nifong. And the results of that poll on March 27th, when he started making all these statements, was that Miss Black had 37% of the voters, and Mike Nifong had 20. So the point at which he starts making all these pretrial statements, he's down 17 points in the poll, and he's only 3 points away from losing the magic 40% that you need for a runoff. Now, you go forward to May 2nd, which is hardly a month later, and Mr. Nifong wins 45% of the vote, and Ms. Black gets 42%, and he wins the election outright. One of the things that's important to know in assessing how in the world that happens, and the background is that Ms. Black, who he fired from the DA's office immediately upon taking over, they were bitter rivals, also had gotten a significant amount of media attention as a result of her involvement in the Mike Peterson trial over in Durham, and had lots of media exposure, lots of name recognition. Mr. Nifong was essentially unknown, hadn't even tried cases, at least in Superior Court, in 6 or 7 years. So he really didn't even know the lawyers very well over in Durham, at least not the ones that did Superior Court work. So what happened in those 35 days? Well, part of what happened is Mr. Nifong found a way to get himself a lot of media exposure. He went on, as we saw, on Dan Abrams. He went on all the local stations, that's REL. He went to forums. This is the one at NC Central. He went on the Today Show, again back on MSNBC for a different spot, again back on the Today Show, the early show, CBS Evening News. Here he is doing the chokehold again, and of course the Candidates Forum. So he turns himself from being a virtual unknown to, I would say, probably the most recognizable prosecutor, by name at least, in the entire country in the span of 35 days by doing all these interviews. The other thing that happened was the types of statements that we saw him making. The press just, like the rest of us, was just astonished, and they couldn't get enough of it. And so they just kept running these stories over and over and over again. And comments that he made, because they were so inflammatory, got picked up by every media outlet, virtually certainly in the nation and even internationally. And these are just some of the, I don't think we ever got a complete count, but it was hundreds, if not thousands, of articles where his name appears in all different publications. And he does it not, his defense to a lot of this stuff on the pretrial statements was, well, I was just trying to get them to cooperate and get information. But the problem with that defense, in part, was that he wasn't just doing it with NBC and the local stations. He was doing it on the O'Reilly Factor, USA Today, Good Morning America, New York Times, Newsweek, all these organizations that have nothing to do with the local Durham County election. ESPN, hard to understand how it is that he's going to collect information by talking to the reporter from ESPN. And effectively what happened is that in 35 days he goes on what really was an unprecedented media barrage. Not seen, I think, anywhere in the country, never mind here in the state, not in the state, probably not in the country. He gets a 25% swing in the polls in 35 days, and of course he wins the primary. And the Disciplinary Hearing Commission that considered this said that based on that evidence, they could come to no other conclusion than that his statements and the obvious violations of the rules were motivated by his personal desire to become reelected as a district attorney. And they found that as a significant aggravating factor for this aspect of the case. And I'll just wrap up. We started off by saying the lessons in the Duke Lacrosse case. There are lots of lessons in there if you're a prosecutor, obviously, or if you're a defense attorney. But I really think there are lessons that go beyond that. And I think one of the ones that you can take out no matter what kind of practice you do is to always guard against allowing any kind of personal motivations or feelings to seep into your work. Very easy to say, very hard to do sometimes. And that's anything from maybe you not crazy about this client, or you have some strong feeling and you don't really want to advocate. So, that's certainly one lesson that comes out of it. And it's probably a good reminder, even though the vast majority of cases certainly don't have anywhere near this kind of media attention, to just remember that cases are to be decided in court, and you just need to be real careful about how you talk about cases, even in casual conversations. All of us are guilty of talking about things. Hopefully you talk about it in a way that doesn't identify anybody, but it is a good reminder that you really need to try to limit that as much as possible. And I'd be glad to answer any questions, but I know I don't want to take up Brad and Joe's time. If there's one or two questions, I'll be glad to answer them. Otherwise, I'll let them talk about some other aspects of the case. Thanks.
Thank you, Doug. I'm Rick McElroy. It's my pleasure to introduce our next two presenters, Joe Cheshire and Brad Bannon. Their topic will be ethical and professional duties of disclosure and duties of candor to a tribunal. They probably need a little introduction, but Joe is the founding partner of Cheshire, Parker, Schneider, Bryan, and Vitale. In Raleigh, I think one of his amazing facts is he's prosecuted or tried cases in 84 of the 100 North Carolina counties. Brad Bannon is a member of the firm Cheshire, Parker, Schneider, Bryan, and Vitale. And both, of course, have devoted their lives to representation of criminal defendants. At this time, please welcome Joe and Brad. Thanks.
Thanks a lot. It's amazing to see so many of you all here. I'm Joe, by the way. I'm an employee of what we call the Bannon Group now. My senior partner, Brad Bannon, will speak to you in a moment. It's interesting being up here on this stage for me because the last time I was here, some of you were here. It was about 11 years ago, and there was a roast for my dad, who has since passed away, and it's very poignant for me to be up here and remember my dad. And there's a story I like to tell about the Duke case. We're supposed to talk about candor to the tribunal, and we'll talk about that a little bit. But my dad, when he was on his deathbed, was right after this case, right after it started. And he was still very lucid, and he said to one of his friends, he said, when young Joe got out of law school, he said all he wanted to do is be a criminal lawyer. It's all he ever wanted to be. And I told him, I said, son, you just can't do that. You got to go be a civil lawyer, because if you ever touch that criminal law, it's like a narcotic. You can't ever get away from it, and you need to find out what it's like to be a civil lawyer. So I did. I went and was a civil lawyer for 5 years and tried 35 jury trials as an insurance defense lawyer, and found out how easy it was, because if you were going to lose, you just settled. And the whole time I was doing that, I was building my criminal defense practice, and I finally left, and Dad said to his friend, he said, yeah, and he said, it took me a long time to get over that. My son was out there representing rapists and child murderers and just the worst people in the world, he said. But I finally got used to it, and not only did I get used to it, but I actually grew to be really proud of him and proud of what he's done. And he said, and now I'm on my deathbed, and damn if he's not out there representing a damn Duke athlete. He said, I just don't know if I can go to my God with that on my conscience. If you all, the ones of you that are in here, knew my dad, you'd really appreciate that. I was much less profane than he was. I want to talk to you a little bit about the Duke case generally and follow up on some of the things that Doug said. And then I want to talk to you also about candor and candor in our profession, and how the Duke case is another example of things that happen in our profession that we don't like to admit actually happen. And I want to say to the ones of us that are here in Wake County, of course, I've practiced law here in Wake County my whole life, and my dad practiced law here in Wake County for 63 years. And I have actually, it's now 85. I've been in trials in 85 of the 100 counties in North Carolina. I'm not sure there's another criminal defense lawyer that's ever done that. But I've tried cases from Manteo to Murphy. In fact, I'm one of the few people you'll ever know that was in court in Manteo on Tuesday and Murphy on Wednesday. So I have seen the state of North Carolina up close. I've seen its juries, I've seen its clerks, I've seen its prosecutors, its defense lawyers, its civil lawyers, how it conducts its business. And I don't say this because I'm a Wake County lawyer. I say this because it's true. We have a different kind of bar here. We have a bar that for some reason has always been close and has always been together and has always been together and has always been proud of itself and has quite often disciplined its own in a very quiet, nice, reasoned, professional way without it being made public, and in a way that's taught its lawyers. Now we're growing huge, and it's harder to do that. But I hearken back to remembering when I was a little boy. Some people like George Anderson here will remember this, Bob Emanuel and others, where all of the lawyers got together at the S&W downtown in little round tables and had lunch with each other every day. And then afterwards at Belk's and have lunch with each other every day. And when I was a young lawyer and I was in court and I was screwing up, Earl Purser or Robert McMillan or George Anderson or Carl Gaddy or somebody would come take me into the side room and teach me and tell me how I was screwing up, and how judges would tell me and take me into their chambers and teach me and help me and make sure that I didn't screw up, how prosecutors would help me. I'll never forget, as a young lawyer one time, getting a telephone call from a very, very prominent member of the bar who I was terrified of. And he said to me, Joe, you were supposed to file an answer in the case of Smith versus Jones yesterday, and you didn't file it. And I said, oh my God, you know how to sweat. And he said, when do you think you could have it filed? I said, I could have it filed by 5. He said, well, look, if you have it filed by Friday, that's okay. I don't think that would happen today. But in Wake County, we do have a county that's different. One of the lessons that I want you all to know is true about the Duke case is that the things that you have heard here from Doug Brocker today and the things that I'm going to tell you and what happened in the Duke case happens in North Carolina every single solitary day. Innocent people are prosecuted every single solitary day. Games are played in our courts every single solitary day. Judges are not told the truth every single solitary day. Lawyers that represent indigent defendants aren't prepared every single solid day in this state. I'm chairman of the Indigent Defense Services Commission. We're now over a $100 million state agency providing indigent people in North Carolina with juvenile lawyers and DSS lawyers and criminal lawyers and those types of things. It has been stunning to me to watch our practice need to get better and more professional. And it is something that we all need to be true to ourselves about. the knowledge that we can be better and that we have to watch ourselves and make each other better because we are a family. And when you get into the Duke case, because what the Duke case was, ladies and gentlemen, and I've been all over the country now speaking about it, and I have had hundreds and hundreds of lawyers and judges particularly call me and say, thank you all so much for showing the world what happens every single solitary day in our courts. And one of the things that it has taught us is about candor, and Brad's going to particularly talk to you about candor to the tribunal. But I want to talk to you also about some other candors, and that is the candor that we as a profession owe to each other. Candor is defined in the dictionary as unreserved, honest, and sincere expression. And I really do feel like, maybe it's because now I'm in my 60s and I'm an old man and I look back at the world and I think the world was always better than it was now, because I think you have a tendency to do that when you get older. But I do recall when I was a young man that we were freer with our honesty about our cases with our opponents than we are today. We weren't as afraid to be candid with each other. And so I think it's something that we need to think about, candor and honesty to each other. If we really talk about our cases in a candid, in an unreserved, honest, and sincere way, quite often we can resolve them. And whose benefit is it that we resolve our cases? It's our clients. And that's who we owe our duty to, not to ourselves, not to our pocketbooks, not to the big cars we can drive, but to our clients. And with candor within each other, not only comes respect as we have so often in our bar, but it also allows the public to have respect for us. Candor to our clients. One of the things that Mike Nifong did not do was show candor to his client, the state of North Carolina, to the accused woman who was clearly enormously troubled. He had access to her mental health records. She was an enormously troubled woman. I actually kind of feel sorry for her. Some ways I don't, some ways I do. But he owed a duty of candor to her. He didn't have a candid conversation with her. We owe candid conversations to our clients when we need to say to them, you are going to lose and you need to settle. You are going to go to prison for 20 years if we go to trial. I'm not going to let that happen to you when you can go to prison for 2. We need to have that candidness with our clients and not do what our clients always want them to do because we think that's our job, but to make sure that we counsel them to do what's in their best interest. We need to show candor to the public, and this is the real thing that he hurt us with so badly, Mike Nifong. He didn't show candor to the public. He lied to the public. And I see this happen too. It's a scary thing because the public has this perception of us as if we're just piranhas. We just fight, we just hate, we just rip apart, we just bill, we just do all of those things. And one of the reasons is because I don't think we're really candid with the public about who we are and what we do. We do a lot of make work to make it look like that we're wonderful, nice people, but we need to be candid to the public. And last and most importantly, as Brad will talk to you and I will as well, we need to be candid to the tribunal. But also I want to say about that the tribunal needs to be candid back to us. And I think this is something that all of us are so afraid of judges and so afraid of making judges angry that sometimes we don't put enough responsibility on judges for where we've come. It seems to me that where we've come is we've become, at least in the courts, not only a litigious group, But we've become a group that fights among ourselves, that distrusts each other, that the more days go by and years go by, the more distrusting we are as litigants of each other. And I think that's because we're not showing candor to each other, and I think it's because the courts don't enforce that candor. Now, is that difficult? Is that hard for the courts to do? Yes, that's hard for the courts to do. But I think the courts owe us a duty of candor, just like we owe them a duty back of candor. The Duke case was a study in professionalism from two sides. One is going to be the self-serving statements I'm going to make to you about our side, and the other is going to be the side that Mr. Brocker has clearly presented to you. And I want to emphasize that although these things happen in North Carolina all the time, and particularly, let me tell you, to poor people, there is a different justice, and the Duke case shows that there is a different justice for poor people and for rich people. I submit to you that had the Duke 3 been poor African Americans or Mexicans with the small resources that they would have had because it wasn't a death case, with lawyers getting paid amounts that, I don't know what y'all's overhead is, but most overhead studies show that overhead is around $58 to $60 an hour, and indigent lawyers are getting paid $65 an hour and just getting a raise at the first of the year to $75 an hour. That probably some plea would have been worked out and they'd have each done 3 or 4 years to some low-level felony. Or certainly they would have been convicted felons. And the probabilities of all of the things that Mr. Nifong did, he would have been able to do because he would have gotten away with it. And one of the examples of that is candor to the tribunal that I want to talk about briefly. In one of the early court proceedings, I was asking the judge to order Mr. Nifong to give us the report of his conversations with DNA Securities, and all of you now, I'm sure, know about DNA Securities. It's what brought him down. It's the report that they didn't present us with the exculpatory evidence that showed unquestionably that the boys were innocent. Mr. Nifong said, and I won't tell you who the judge is, it's a very prominent, very fine judge, but Mr. Nifong said, Your Honor, I didn't have any meaningful conversations. We now know, of course, that he had many meaningful conversations. The judge, so I don't need, there's nothing for me to give, Mr. Cheshire. I said, well, Your Honor, I'd like to have it written down. Denied. Well, Your Honor, if you would ask him to write it down and submit it to the court so that the court can look at it and determine whether I'm entitled to have it under the new discovery law. Denied. Well, Your Honor, if you would have him write it down and put it under seal so that we can have it in the court file so that if this case goes badly, we can appeal. Denied. It was amazing. And the reason is because there's been a history in this state, and I'm sure it's in civil cases with certain civil lawyers, that judges believe that prosecutors tell them the truth. And so when a prosecutor says he or she doesn't have something, well, they just believe it. And so you don't get it. Happened in the Gale case, happened in the Hoffman case, happened in this case, happens all the time. And the great thing about this case is it's shown the light on the fact that everyone doesn't tell the truth in the court. But the issue is the reason that we have to have a duty to the court of candor and honesty is so the court will not make a ruling like that. I know this judge feels bad about those rulings. I still think he was wrong about those rulings. But we owe that duty of candor to the court in order that the court can make those proper rulings. But let me talk to you just a minute about Mr. Nifong. Out of the gate, he was unprofessional, and he was not candid. I wrote him a letter after he started these conversations in which I said, Mike, you're violating the canons of ethics. Here they are that you're violating. Please quit. If you don't quit, we're going to have to go out and talk to the press. If you do quit, we'll just try the case. It was the afternoon he got that letter that he showed the chokehold on national television. His comments to the press, as Doug have said, were unbelievable. We asked him to meet with us. This is candor to each other, to lawyers. He refused to meet with us. We had exculpatory evidence to show him. Reed Seligman's lawyers had an absolute, complete alibi to show him. He refused to meet with us. He refused to meet with Reed Seligman's lawyers. He accused Reed Seligman's lawyers of misconduct. When finally Wade Smith, and we all know Wade, who could not want to meet with Wade? So we finally met with Wade, and Wade said, Mike, I want to talk to you about this, and this is what he did. Wade was there with 3 other lawyers. You won't believe this. This is what he did. He went like this. I don't want to hear. He actually physically did that. Unbelievably demeaning. He made personal attacks in court on Kirk Osborne. He said in response to my desire to get some of the rape kit issues, if Mr. Cheshire knew how to try a rape case, he would know so and so and so and so. To which I leaned down and said to Brad as he was talking, Brad, write down the date and time he said that, because he's going to regret he ever said it. He accused the attorneys of being on a witch hunt. When Brad kept asking for the DNA material, he said to the judge, the definition of insanity, Your Honor, is a person who asks for things over and over again thinking they're going to get a different result. It wasn't just one time that Mr. Nifong was not honest with the tribunal. It was many, many, many times. And we finally got a judge who had enormous courage. And I don't know how many of you all know Judge Osmond Smith, but he is one of the great judges in this state. He is a courageous man with no axe to grind on either side of a case. And finally, thanks to Judge Smith, and also let me say an interesting fact that very few people really know about, thanks to the State Bar in filing their actions against Mr. Nifong. But you know that those actions came out of the State Bar by the chairman of the group, which had, I can't remember how many people in it. Do you remember, Brad? A significant number of people in it, breaking the tie. Broke a tie. Otherwise, the State Bar would have never filed that grievance when they filed it. And if Brad Bannon hadn't done the unbelievable job that he did of uncovering the conspiracy of lying that he uncovered in the DNA, we would have gone to trial in the Duke Lacrosse case. And what Mr. Nifong knew and believed was that in Durham, we were never going to lose. But in Durham, we might never have won. And that's really what he was banking on the whole time. That's what he thought, and he thought he could get away with it, and he thought he could get to the jury, and he thought he could get to a hung jury, and everything would be okay. The last things that I want to talk to you about is that when we talk about our cases, as Mr. Nifong did, or even in smaller ways, we create ripples throughout the system that are very damaging to people. And in this particular case, they were very damaging to these boys in so many ways other than just the ones that Doug talked about. This man was an elected prosecutor, and we also ought to and have to hold our elected officials to a high level of professionalism. We all are held to a high level, but particularly our elected officials, because when a prosecutor speaks, cloaked with the robe of his or her office, people believe what they say. It wasn't just threats to these boys. They were putting up wanted posters with their pictures on them. They had marches outside their house calling them to be castrated. They had Duke professors who called them rapists in class. And Duke's response basically ignored the presumption of innocence. They have since apologized for those, but many of the people that did and followed Mr. Nifong's lead never have apologized to these boys. I don't know what would have happened also if I hadn't gotten mad one day when Nifong refused to quit, and I called a press conference in my office. Nobody wanted to have that press conference but me, but I was mad. We had all of the national news media in my little office. Not a big old fancy office, just a little office in the old Alexander building. They were all there. LA Times, New York Times, every cable TV, every national news broadcast. And I was pointing my finger at them like this, saying, you all have got this wrong. You're destroying people's lives, you're believing a lie, and you're going to be embarrassed. And I was pointing my finger at them. And what was going through my mind were two things. When you watch Bill Clinton point his finger, you said, boy, he shouldn't be doing that. And the second thing is, man, I sure hope these boys are not guilty. When it became, I'm going to turn this over to the chief executive of the Bannon Group here in a minute, Brad Bannon. But I do want to tell you all something about Brad real quickly because it's really an extraordinary story. He won't tell this story, and some of you may have heard it, but I want to tell it. Brad did all the motions in the Duke case except for the change of venue motion. The work he did, if you want to see the best criminal law legal work that's ever been done in the state of North Carolina, you come look at the Duke case file. Brad did it all except for that one motion. And he doggedly pursued the DNA because he instinctively knew there was something there. And it was an amazing thing when he finally, on behalf of all the boys, got all of the underlying data from the DNA lab. And I want to tell you a story about it because it's an inspirational story for every lawyer, particularly lawyers that do trial work. We got the data, it was like this much, thousands of pages, all graphs, charts, scientific stuff. I walked in the office on Monday morning. Brad was in the conference room, had all these papers all over him, and he'd gotten a textbook on DNA from Amazon.com, which he had read all weekend. I left like I do every night at 7 o'clock. Brad was in the conference room. I came back the next morning at 8. Brad was in the conference room. I left at 7. Brad was in the conference room. Wednesday, the same thing. Thursday, the same thing. Friday afternoon, the same thing. Friday morning, Friday afternoon, he comes into my office and says, you won't believe what I think I've just found in this underlying data. That's what a trial lawyer's all about. He went up to meet with the former head of the FBI DNA section, and the guy asked Brad where he got his PhD. Brad said he got an English degree from South Carolina, something I'd have had a hard time admitting. But anyway, once Brad found the DNA, he pursued the sanction motion, and so I want him to talk to you about candor to the tribunal and the sanction motion that was filed. Thank you all.
Hey, how y'all doing? I'm not the only lawyer that worked on the Duke Lacrosse case. Lots of lawyers did. I'm the only lawyer who really concentrated on the DNA, and that's what really provides the backdrop and the context. Well, it's a lot of people. The backdrop and the context for this issue of candor to the tribunal. Just to let you all know, there were 2 sets of DNA tests done in the Duke case. The first set was done by our State Bureau of Investigations crime lab. They had obtained swabs from all 46 white members of the Duke lacrosse team because the accuser in the case had said she had been attacked by 3 white lacrosse players who did not wear condoms and raped her orally, vaginally, and anally. So they were quite interested in Mr. Nifong. Actually, in a lot of his preliminary comments that Doug talked about, was quite interested in the return of the DNA test results. He would make comments like, "We're going to wait to charge people until the DNA gets back." And it was clear to everyone that if this accuser was telling the truth, there would be an enormous amount of DNA evidence to implicate one, if not all, of the people who had allegedly attacked her. The SBI conducted tests on various evidentiary items, including what people who do criminal law work know, even people like Joe who don't know how to try a rape case, know what a rape kit is, and that's if somebody reports being sexually assaulted in a relatively close proximity in time to when it allegedly happened. The hospital will obtain evidence from their person and their body that hopefully can be tested for the presence of foreign DNA. To identify the assailant or to clear people who didn't do it. So anyway, in this case, a rape kit was generated within a couple of hours of this alleged attack. Also, police had seized some fake fingernails that were found in the trash can in the bathroom of our client, Dave Evans, who was one of the kids who had cooperated fully with the investigation, given one of the statements Doug flashed up earlier. So the SBI lab tested all these materials. The rape kit, they actually tested for the presence of semen first. There was no semen on any rape kit item. The SBI lab doesn't even test for DNA when they don't find semen on rape kit items, so they did not forward those items for DNA testing. They did find some DNA on the false fake plastic fingernails that were seized. They identified it as primarily being that of the accusers. Said there were several other people there in the mixture, but they could not identify who those people were, couldn't make any comparisons to the reference samples that had been obtained by the players or from the players. So what Mr. Nifong did is he sent those evidentiary items off to a second private lab that he retained, named DNA Security in Burlington, North Carolina, run by a guy named, at the time, by a guy named Dr. Brian Meehan. When Mr. Nifong sent these items off to Dr. Meehan, Dr. Meehan prioritized testing the rape kit items first, which he had done and completed by April the 10th of 2006. He met with Mr. Nifong on that day and told Mr. Nifong, it was one of the first of 3 meetings that he had with Mike Nifong, which is also fairly unusual. We have at least one very experienced felony prosecutor in the room. I don't know of any prosecutor who's ever met personally on 3 separate occasions with a DNA testing facility lab director. But in any event, he met for the first of 3 times on April the 10th. He was told on that date that the rape kit had revealed the presence of at least 5 or 6 different men. One of them was the person the accuser had identified as her boyfriend. The other, they couldn't identify who it was. But what they could say with 100% scientific certainty was that those 5 men did not include any of the lacrosse players, including the people that Mike Nifong would seal indictments against 2 days later. He went back a couple of weeks later. He had another meeting with Dr. Meehan. Dr. Meehan once again told him about the rape kit items, and then he began talking about fingernail mixture identifications and said, I think we may have found one of the players' DNA on the fingernails in the fingernail mixture. And Mike Nifong looked at him and said, I bet it's Dave Evans, isn't it? And Dr. Meehan said, how did you know? And then anybody who's read the underlying data in this case knows that Dr. Meehan spent, and you can trace it like you're looking at footprints, he spent the next couple of weeks before he finalized his report doing everything he could to identify Dave Evans as a person whose DNA was in that mixture, including getting in touch with the SBI lab and asking for their protocols and their charts to make sure when he finally made the call that it was Dave Evans, it wasn't so far off the chart of what the SBI had done, because as you'll recall, the SBI had Dave Evans as reference sample and refused and declined to make that call as a DNA match. So that's the context for which we began seeking information in this case about the DNA testing. We sought it on two separate tracks. Number one, we wanted to know, as Joe alluded to, what went on in these conversations, these three conversations that you had with this lab director in the presence also of the two lead case detectives. And number two, the underlying data. I don't have enough time to get into all the rules that are applicable in criminal law and Chapter 15A for what the state has a duty to disclose. It's a separate and distinct duty under our statute. Thankfully, our North Carolina statutes give criminal defendants greater, wider rights as it relates to obtaining information and investigation than even the United States Constitution does. The Constitution requires prosecutors generally to disclose what's called Brady material or exculpatory evidence, which is any evidence that tends to negate the guilt of an accused person or mitigate his punishment. Our statutes basically require the prosecution to give defendants in North Carolina everything except their own work product and their own privileged material. So we sought the substance of that information beginning in May of 2006. Mr. Nifong began making a series of representations in court about both of those things. Specifically, he stated to Judge Ron Stevens that when Judge Stevens, when Joe, well, I just told you who the judge was that Joe had his exchange with, but sorry. When Judge Stevens, we appeared in front of him in one of the first settings, we asked again for the substance of any non-privileged information that he obtained in these meetings. Mike said they already have it because they have the report. And by the way, what I didn't tell you is the report this private lab issued when they issued their final report in May only stated the findings from the rape kit of the boyfriend. It just said all we found was DNA from the boyfriend. It said nothing about the DNA from the other 5 unidentified players that had been found. It also didn't state what I later learned when I looked at the underlying data, which is that some of the lab director's own DNA had contaminated the rape kit. In other words, there was more of his DNA in the rape kit than any of the 3 people that the state of North Carolina accused of committing this rape. And so none of that was in the report. We asked Mike about what he had learned in these meetings that wasn't privileged. He said nothing. That's when Joe engaged in the exchange with Judge Stevens. And, it doesn't make Judge Stevens a bad guy. All it proves is what we're here today to talk about, which is why it's important to be candid to the tribunal and candid to everybody in the process. I mean, it wouldn't dawn on me, even if you're going to lie to me, I've been lied to plenty of times in my life. I'm ready for it. It wouldn't dawn on me to think that a lawyer would stand up in front of a judge and lie to a judge. It wouldn't dawn on me that a prosecutor would stand up in front of a judge and lie to a judge. It certainly it was beyond even what I thought Mike Nifong was capable of doing to stand up in front of the man he worked for, who was a very respected judge in his jurisdiction, and flat out lie to him. But that's what he did. And that began the record that was created of the breadth of this misconduct. And I think that while certainly, he violated a number of different discovery rules, we don't have enough time to get into what the rules of discovery he violated were for criminal cases. But since this is an ethics exercise, we can talk about the ethical rules that he violated. And you all know that Rule 3.3A1 prohibits a lawyer knowingly making a false statement to a tribunal. Most importantly, it also prohibits the failure of a lawyer to correct a misstatement that's been made to the court, or to correct any perjured testimony or any false testimony. And that's very important in this case because as soon as Mike Nifong's misconduct and the breadth of it was exposed in this case, he began doing what lots of mine and Joe's clients do, and that's tell different stories about what happened. And that's when they're probably not telling you the truth about what happened. So this record had been created through these exchanges in court and through these letters because he wouldn't speak to us, so we would write him letters saying, hey, since you won't talk to us and give us anything, can we just agree we'll talk about this in court? And then we would copy the judge, and so we had to deal with all these issues in court. That's the importance, is if we can't rely on lawyers to tell the truth to the public, whether it's in extrajudicial comments, to each other, whether it's in meetings in offices or in open court, and certainly to the court, this system will come to a halt, as it kind of did with the Duke case, because the state bar had to intervene heroically, because we'd be in a trial if it hadn't been done. I have absolutely no doubt about it. Mike Nifong would have let go of this case only from his dead cold fingers. That's the importance of telling the truth. Which I think, and I think a lot of people in this room probably think, is what the process is about, and the reason that a lot of us became lawyers. One of the things that I want to talk about also is why we, at the conclusion, and by we I mean all of the defense lawyers who represented all three defendants, filed this motion, because I get it that Mike Nifong has been dragged through the mud about as much as any lawyer in the history of lawyers in this state and maybe in the nation. But we watched as we had filed this sanctions we had prepared this sanctions motion, which is in the materials, within a couple of weeks of the revelation in December that he had lied to the court on multiple occasions and had lied to us and had withheld all this information. When Judge Smith learned this on December the 15th, after Mike Nifong had said to him twice before court convened and then once court convened, when I got the defendant's motion to compel discovery saying that they had found all this DNA, it was the first I heard of any of all this. And I was like, whoa, and these are obviously issues the defense needs to know about. And so I've got Dr. Meehan here, who was their expert, to testify and answer any of the questions that the defense had. In that moment, once again, if you were to have believed anything Mike Nifong said later on, it was his duty under Rule 3.3A1 and the comments thereto to bring that to the court's attention and say, my God, Your Honor, all summer and fall I've been lying to you about this report, or at least not telling you the truth. I've been misrepresenting the truth about an issue that is of utmost importance in our criminal justice system, which is exculpatory evidence. I've gone ahead and ordered this expert to do a full report, and I've got him here to answer any follow-up questions. But he didn't do that. Instead, he said, this is the first I heard of it, and offered this person up for testimony. And at the conclusion of that, you would have had to have been a rock with no brain not to know that Mike Nifong had lied throughout the proceedings to the court about these things. And so Judge Smith looked at us and said, just like this, do you have any additional motions you'd like to make right now? And it was clear, I thought, to all of us that he was offended, but that he wanted us to sort of pursue whatever relief we deemed appropriate. And of course, and again, I'll toot our horn, we weren't going to start flailing our arms around and start talking about dismissal, because we needed to be able to review all these materials to do what officers of the court should do, and that's be professional and make sure before you seek relief or accuse anyone of doing anything wrong, whether it's a fellow lawyer or another or a potential criminal defendant, you know what you're talking about. And so we did that, and we reviewed all these materials and drafted the sanctions motion, and we're about to file it until Mr. Nifong recused himself of the case, and it was handed over to the Attorney General's, at which time our work became completely refocused. We did not care about Mike Nifong or what he had done wrong. We cared about bringing our clients who were innocent and had been innocent from day one through this process as quickly as possible. We knew that it would have derailed any meaningful attempt to get these charges dismissed if we filed a sanctions motion asking for the court to, because the Attorney General would have had to defend Mr. Nifong's conduct, because we would have also, of course, moved to dismiss the entire case because of the outrageous conduct of the state of North Carolina through Mr. Nifong, and we declined to do that. And to his credit, Judge Smith did not intervene sua sponte, which he could conceivably have done, and one of the most ill-advised things that Mike Nifong ever did when he was responding to the state bar's allegations of misconduct, he said, if I'd really done anything wrong, Judge Smith would have written y'all and said that I did something wrong. So you have to not hold me accountable under that theory. But Judge Smith remained a neutral Superior Court judge, and he let this process complete itself. And we felt, and I do want to, I know I'm going over our time, but I do want to call your attention to a comment. It's actually comment 12 to Rule 3.3A1. And it is under the heading of preserving the integrity of the adjudicative process. Lawyers have a special obligation to protect a tribunal against criminal or fraudulent conduct that undermines the integrity of the adjudicative process. We have a duty, people, to make sure that the truth prevails in a courtroom. A lot of people were thinking, why did they file a sanctions motion after Mike Nifong was so publicly completely professionally destroyed by competent doesn't begin to describe the state bar's prosecution of Mike Nifong. But after that process, why file this sanctions motion? And the reason is at the heart of that comment to the rules of professional conduct. We had a duty to this process and to Judge Smith to put in front of him the issues that are separate and apart from lawyer misconduct and separate and apart from protecting the public. And they are protecting the integrity of the judicial process. And so we put it in front of him. And we put it in front of him in the motion that is in your materials. And as a result of that, he issued an order to show cause not only on our own motion, but on his own motion. Why Mike Nifong should not be held in criminal contempt of court under Section 5A-11, and that's what I'll close with in talking about that. Not only do you face, as lawyers, the potential for being disciplined under the rules of professional conduct by a judge and sharing concurrent jurisdiction, the North Carolina State Bar, but I believe what the proceedings against Mr. Nifong have now shown us all is that as lawyers, you now face jail time if you knowingly misrepresent material facts to the court. The criminal contempt statute includes as criminal contemptuous conduct willful behavior committed during the sitting of a court in its immediate view and presence and directly tending to impair the respect due its authority. That is the theory upon which Judge Smith pursued Mike Nifong for criminal contempt, because Mike Nifong had looked at him like he looked at Judge Stevens 2 months earlier and said, I've given them everything that Dr. Meehan told me when I gave them the report. He charged him with a crime as a result of that, and he found that he had knowingly and willingly made those misrepresentations to the court, and by definition had therefore engaged in criminal contempt. So there are lots of lessons to be learned from the Duke Lacrosse case. Like Joe, I'm very passionate about this criminal justice system. Like all of you, I'm very passionate about it in my home state of North Carolina. I was offended by what happened. I was offended by the way our state ended up looking across the United States, and I was glad to be a part of a process, not just the defense lawyers, but the North Carolina State Bar's activities. Everybody who, the Attorney General's office who took over and had the courage not just to say we're not going to pursue this case because we couldn't win a trial, but these young men are innocent because it was the truth. And that is the end of what candor is all about. This is a process and a search for the truth, and that's all, if you keep it in mind, you need to know, and you'll never be in jeopardy of violating the rules or going to jail for 24 hours in Durham, whether you have supporters there for you or not. So I appreciate you letting me talk to y'all, and Joe too, and unless anybody has any questions, I'll go. Thanks.